Should I wait the full 5 years to apply for citizenship? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, and Washington, D.C. So, for most green card holders, most lawful permanent residents, they have to wait 5 years to apply for citizenship. So, once you get your green card, once you have your start date on your lawful permanent residence, you start counting 5 years from that date and you can apply for citizenship, naturalization, to become a U.S. citizen. Now, the rule does say that you can apply 90 days early, and a lot of times people do. We're going to ignore those 90 days for the purposes of this video. We're just going to talk about the general rule of whether you apply on the 3-year rule or the 5-year rule. So as I mentioned, most people have to wait the first 5 years, but there's a certain type of people who can apply after 3 years, and those are people who are married to U.S. citizens. So if you get a marriage-based green card and you've had your green card for 3 years, you can apply for citizenship 2 years early. That's one of the benefits of getting your green card through marriage. Now, one little side note is that if you have received your green card through some other process, let's say through asylum or through the diversity visa or through employment, and you then marry a U.S. citizen, if you have 3 full years of marriage to a U.S. citizen and 3 full years of your green card, you can take advantage of that 3-year rule, even though you didn't get your green card through the marriage process. So this rule applies to those kinds of people who got their green cards, have had them for 3 years, and can apply for citizenship under the fact that they're married to a U.S. citizen. Those are a great benefit to having a green card and being married to a U.S. citizen. And I want to talk to you today about whether or not it makes sense. It doesn't always make sense to apply for the 3-year rule. And one of the things that I say a lot in immigration is just because you can doesn't mean you should. And that rule certainly applies here when people are thinking about applying after 3 years. Well, what in the heck do you mean by that, Jim? Why in the world wouldn't I go ahead and apply for citizenship if the law says that I can? Well, here's when you wouldn't. If there's been any kind of problems with the marriage, if the marriage is shaky, if you've been fighting, if you've been living apart, if somebody's gotten a restraining order against someone, if someone has written a mean letter to USCIS, if there's anything that makes the marriage just a little bit shaky, our current advice for most people is to wait the full 5 years. Now, it is certainly easier to prove up a marriage under the 3-year rule for citizenship than it is to get that initial green card. They are not going to hold your marriage to the same level of scrutiny than they did when you filed the I-130 or even when you filed for removal of conditions on the I-751. So that is a fact. But at the same time, if there has been discord, if there has been fighting, USCIS might find out about it, and they might start to wonder about the original marriage itself. They might deny the citizenship case overall. They might call the U.S. citizen spouse in to ask them questions. In most 3-year citizenship cases, the spouse should go to the interview and will probably sit outside. Most likely, they're just window dressing. Most likely, they won't be called in. Now, I think it's very important for the spouse to attend, and I think it's very important to bring updated marriage evidence. But for the most part, I believe that if the officer just sees that your spouse has come with you, that they care enough to see if you're going to get your citizenship case approved today, that's usually enough. And usually, 9 times out of 10, the U.S. citizen spouse sits outside and they don't even really come in. When you show up without your spouse, or when you apply after having fought with your spouse, that's when problems can occur. This is especially true because USCIS has started holding people to a higher standard on this 3-year rule. That is, they are taking the position that you have to have lived together sort of nonstop for the full 3 years. So if you have times where you updated your address with an AR-11 with USCIS and moved out, or when you went overseas to stay with grandmama for a while, they are really being harsher on this rule and trying to make most people go the 5-year route. So this is an important question, whether you're going to apply on the 3-year rule and the 5-year rule. And there's one other reason why I want you to think about this. So I believe that if USCIS gets an application for someone on the 3-year rule and they sense that there's been any kind of marriage fighting or problems, they simply won't approve the naturalization case. They'll just sit on it. And do you know why? They want to see if the marriage falls apart, because if the marriage falls apart, then they can deny the case and tell the person you have to apply on the 5-year rule. You might not believe me that that's something that happens, but I 100% believe that that is something that occurs. We've seen it many, many times. So just because you can apply on the 3-year rule doesn't mean you're going to get it. So you really need to think these things through. You might want to talk to an immigration lawyer about it. Like I said, my general rule now is if you tell me there's been any kind of problems, that somebody went to court and state court and filed a complaint or started for divorce and then changed their mind, anything like that, we're going to tell you to apply under the 5-year rule. Because when you apply under the 5-year rule, you don't have to prove up the marriage again. They have the right to inquire about the marriage to see if the green card was properly issued in the first place, but they are most likely not going to spend a whole lot of time going back to revisit the marriage if you apply on the 5-year rule. Now, I know some people say, well, Jim, I want to get going and applying for my mom and dad or somebody else. I really need that citizenship. That may be true, but that doesn't mean that you should still go ahead and apply under the 3-year rule if any of those issues that I just raised are true in your case. If you're thinking about applying for citizenship under either the 3-year rule or the 5-year rule, and you want to talk to me about it or call our firm to think about hiring us, you know the number, 314-961-8200, email info@hackingimmigrationlaw.com. That is for people who want to hire us. Now, if you're just looking for free resources or to run your scenario past me, I have this great thing called the Immigration Answer Show. I go live 3 or 4 times a week. People come and ask me questions. It's not pure legal advice. It's just me talking about the issues that you raise, and sort of then I talk about concepts like I have in this video. We'd love to have you join us there. And the way that you do that is one of 2 ways. You can sign up for our Facebook group. It's called Immigrant Home. Just look for us on Facebook by typing in Immigrant Home. There's almost 11,000 people in that group right now. And then we also have our YouTube channel that you can subscribe to. When you subscribe to the channel, whenever I go live on the show or whenever we post new video, you'll be the first to learn about it. Thanks so much. Thanks for watching, and we'll see you next time.